Welcome back to the UK Supreme Court. I'm afraid we had an interruption of sound just now, for which I apologise. We're now ready to resume, and we're hearing submissions from Mr. Nigel Jones, Queen's Counsel. Mr. Jones.
Lord, thank you. Unless your Lordship wants me to, I won't go over what I've already said, but I'm very grateful. So what I was saying when we stopped it, it's sufficient for PIAC to say that assuming the doctrine exists, the Court of Appeal correctly identified that the facts of this case means that the Court of Appeal's decision was absolutely correct, and this appeal will fail, and that is all our client needs. And as a footnote for this point, just make it now, but I will be coming back to it. You will have seen in section B of our written case that we should also keep the benefit of the Court of Appeal judgment, we say, even if your Lordships are persuaded, which we hope you're not, that there should be an objective element to bona fides. But I'll come back to that during the course of the morning. Now, you will see that we've structured our written case very much in that order. Section B deals with defence of the judgment, and Section C deals with the wider point about the existence of the doctrine and its survival. So with those introductory remarks, may I now go on to a second topic and say simply this, that it's possible in a case of this kind, because one is dealing with erudite and academic subjects, for the basics to get a little lost. And I understand, of course, that TT and their side see the case differently, and it's not their job to eliminate that which doesn't necessarily help them. So forgive me if I spend just a few moments rescuing a few points from the obscurity of yesterday's session. Well, first is this. The terms on which PIAC were prepared to appoint an agent and enter a contact with that agent back in 2008 were entirely a matter for PIAC to decide. I obviously accept that that's subject to statutory or regulatory intervention, but as a common law matter, that is clear. PIAC offered a contract to TT. TT was entirely free to accept those terms or reject them and not enter into the contract. The fact that PIAC was economically stronger was neither here nor there. TT may, this is pure speculation, but it's speculation which is important. TT may have assumed that it would take the risk of being the weaker party. It may have assumed that it could be so successful in selling PIAC seats that PIAC couldn't do without them, notwithstanding their status. We simply don't know. And that is the mystery of commerce, and that are the risks that are assumed every day by contracting parties. And that's why the law leaves them alone, generally, to enter whatever contracts they wish, with whomsoever they wish, on whatsoever terms they wish. Now, that first contract is not impugned in any way, and it's difficult to see, in fact, how it could be. Under that contract, PIAC was entitled to terminate it for no reason at all, as long as it complied with a minimum notice period. And that could be, I think, as little as 30 days or a calendar month. TT knew that when they signed up. Now, during the course of that contract, disputes arose. Pausing there, that is not an unfamiliar scenario to this court. Those disputes arose between the two contracting parties about the proper calculation of commission due to TT. I'm going to come back a little later and go into the nature of the disputes, what they related to, and the decisions the court made about them, because that is quite possibly important. While those disputes remained unresolved, PIAC gave an unimpeachably lawful notice to terminate the contract. So it was not asserted at the trial, it cannot now be asserted, that there was anything in the least bit unlawful about that termination. This is not a situation in which, for example, TT tried to allege that it had the benefit of a contract in which there existed some implied term of good faith, which the notice of termination in some way breached. Now, PIAC reached the point, that is clear on the evidence, when it wished to have different contractual relationships and arrangements with its agents. Indeed, on the evidence, it believed that it had such new arrangements from 2010 onwards. And if your lordships have Mr. Justice Warren's judgment available to you, and I will be coming back to it, so if you look it up now, it won't be wasted. And just to remind yourself of paragraph 260, little 1. 260, little 1, which makes that point. Now, there's a date in that subparagraph of October 2000.
Mr. Jones, I wonder if you'll be kind enough to give the electronic page number, because I only have the judgment in electronic form. Thank you.
Lord, I'm so sorry. Can I come back to that? I've got it in a paper form, and your lordship's caught me on the hop, but I will provide that to you in a sec.
Thank you.
Lord, Lord Hodge, just whilst, so we don't slow down, what I'll do is just read what little 1 says, so that your lordship can have the reference. It says, it's important to note the following matters. PIAC considered, wrongly as I have held, but I have no reason to doubt that PIAC genuinely believed it to be true, that the 9% basic commission had ceased to be payable, having been replaced by net sales remuneration in October 2010. And the reference to that date will come back to for other purposes in due course.
My lord, it's page 297.
I'm very grateful. Now, as a footnote, Mr. Shepherd's concern that you cannot interrogate what a company believed, or that the judge was somehow precluded from making a finding, which he explored that with you yesterday, that you can't make a finding that relevant people, when relevant people didn't give evidence, is belied by the fact that Mr. Justice Warren was happy to make a positive finding in paragraph 2601. In an appropriate case, of course, a judge can draw inferences against a party who chooses not to call what the judge considers to be relevant evidence without reason. But either Mr. Justice Warren was not invited to do so, or he declined to do so in the light of what he found in paragraph 260, little 1. And also in the light of his conclusion that bad faith had not been proved by TT. So the concern that Mr. Shepherd voiced is not a concern that your lordships need to worry about, because the court has ample power to deal with it. In any event, whatever the position was in 2010, PIAC was entirely free to form the view that it wanted new arrangements in 2012 and to implement that view. It was thus entirely free to terminate the existing contract and offer to replace it with a new one. The terms of that agreement, the new one, would fall into the same category as the first one, i.e., in the absence of statutory or regulatory intervention, PIAC was free to offer the terms it wished, and TT was free to accept or reject. So the fact that TT was, as the judge held, of unequal bargaining position in 2012 is actually, greatest respect to Mr. Shepherd's team, neither here nor there. It would make no difference whether PIAC offered to contract on the new terms before terminating the old one, during the notice period for termination, a day, a month, or a year after the first contract came to an end. They were entirely free, lawfully to terminate, and entirely free, lawfully to offer new terms on such terms and whenever they wished. So the law is clear that contracts are negotiated. Everyone is free to negotiate in their own best interests. The lordship's heard about Alford and Miles, so I don't need to go back over such basic stuff. One negotiating party owes no duties to the other. I'm leaving aside misrepresentation and so on and so forth. Without the interventions of those doctrines or those statutes, the result of those free negotiations is an enforceable contract. An economic imbalance plays no part in that conclusion. If you'll forgive me being colloquial, so far so good. It is thus clear that this case turns on the inclusion of clause 6 in the new contract and on nothing else. Now, that was a compromise of an extant dispute. Oh, this is a very important point. Mr. Shepherd has stated that clause 6 required TT to give up accrued rights. But with respect, that doesn't tell the story. There was a dispute about those rights at the time of the new agreement. I will come back to this later. The contract offered to TT included a withdrawal of TT's claims in consideration of a new incentive scheme to be included in the new agreement. That incentive scheme was new, and it was incorporated in the new agreement and was not part of what Pyack believed had been introduced in 2010. Importantly, it has never been suggested, nor could it be, that the incentive scheme was a charade, and indeed TT had been paid money under it in the subsequent account, or it's been included. Therefore, if one stops and considers the effect of compromise agreements which come about to settle genuine disputes every day of the week, this one on the face of it looks unimpeachable. It is trite to say that the court does not consider the adequacy of consideration when looking at the formation of a contract. And as a footnote, and this is really a footnote point, but I think I can make it and I should make it. It's clear from the judgment of Mr. Justice Warren, paragraph 263, and I think I've got a reference for that, Lord Hodge, which is 299. He found that the consideration built into the new agreement did not, quote unquote, render the pressure illegitimate because it didn't provide compensation for past commission. Now, pausing there for a moment, I don't wish to be critical, but it seems to me that that could be said to have put the cart before the horse. In other words, he's decided that there's illegitimate pressure, and then is looking at the qualitatively at the question of consideration to decide whether that removes the illegitimacy. Now, in the case of Nottingham, which we're not concerned with, and I don't want to send your lordships down rabbit holes you don't need to go, but in the case concerning Nottingham, and we see that at paragraph 268 of his judgment, page 300, where he contrasted the consideration paid to Nottingham Travel. So on the face of it, the learned judge was making a qualitative assessment of the consideration built into the respective compromise agreements. Now, that's not a particularly key point for this appeal, but we do say that that was an error, and it shows where the thinking has fallen into error in the judge's judgment. The important point is that while the judge clearly disapproved of Pyack's conduct, the core analysis that I have just walked through shows that everything done by Pyack was lawful, and it sought settlement of what on the face of it were legitimate disputes. So out of this lawful conduct and out of this desire to settle a legitimate dispute, which settlement had a consideration built into it, TT wants to set aside the contract. So the key question is whether those facts should give rise to the development of a legal principle which allows them to do so. Now, I've called it the development of a legal principle, and I know that Mr. Shepherd doesn't agree with me. The appeal he puts is put on the basis that in some way, we on behalf of Pyack are seeking to narrow the scope of the doctrine. We say that is to misunderstand what has come before. We say that in order for TT to succeed in upholding Mr. Justice Warren's decision, it is they who will need to extend the scope of the doctrine to cover not just conduct amounting to blackmail, conduct generally that falls below some social or moral standard as judged uniquely by the trial judge. So what is the origin of a social and moral standard test? And it may be helpful if we just look for a moment, please, at the CTN judgment and have a look at what's been said in this case about Lord Justice Stein's judgment in that case. So, Lords, what I invite you to do, if you'd be kind enough to do so, is to pick up the Court of Appeal judgment. I am going to refer to CTN. The easiest place to find it for this purpose is in the Court of Appeal judgment, and that's paragraph 59. So let me just walk through paragraph 59 with you. Forgive me if I take a moment to read out what is there. Lord Justice Stein said, we are being asked to extend the categories of duress of which the law will take. I'm so sorry, my lord. I beg your pardon.
You'll have to. I'm sorry.
It may assist us all if you're able to give us electronic references, because we're all functioning purely from electronic bundles.
I hadn't appreciated that, my lord. I will.
So if you could tell me which the pages in the electronic bundle, that would be of great assistance.
I will.
Page 221, my lord.
Thank you.
Thank you very much.
So paragraph 59 says this: we're being asked to extend the categories of duress of which the law will take cognizance. So Lord Justice Stein started with the proposition that the case before him, he took view, was a request for an extension. This is not necessarily objectionable, but it seems to me that an extension capable of covering the present case involving lawful act duress in a commercial context in pursuit of a bona fide claim would be a radical one with far-reaching implications. It would introduce a substantial and undesirable element of uncertainty in the commercial bargaining process. Moreover, it will often enable bona fide settled accounts to be opened when parties to commercial dealings fall out. The aim of our commercial law ought to be to encourage fair dealing between parties, but it is a mistake for the law to set its sights too highly when the critical question is not whether the conduct is lawful, but whether it's morally or socially unacceptable. That's the inquiry on which we're engaged. In my view, there are policy decisions which militate against ruling that the defendants obtain payment of the disputed invoice by duress. He then goes on the second part of that quote to talk about the field of protected relationships, which is reference to equity.
Yeah, well, I just wonder, Mr. Jones, whether that's really what this is all about. When he says the critical inquiry is not whether the conduct is lawful, but whether it's morally or socially unacceptable. I mean, if you're talking about the common law, the issue is whether conduct is lawful. But if you're in the realm of equity, then you can apply other standards, including whether conduct is morally reprehensible or unconscionable, as it would be put, and as it. I mean, that's the word used by the Privy Council in the Attorney General case. And as he then goes on to say, outside the field of protected relationships. Well, that's again the language of equity.
It is.
And what's going through my mind is that if you think in terms of the equitable doctrine of unconscionable transactions, there the critical elements are to have a situation in which one party is in a vulnerable position vis-a-vis the other, advantage to be knowingly taken of that vulnerability so as to impose contractual terms, if it's a contract that we're talking about, which are oppressive. And I mean, one can see that. I mean, obviously, the classical examples are to do with personal relationships and vulnerability of a, because somebody is elderly or in another age, a woman, or whatever the reason might be. And the sort of tendency in the cases we're looking at is to treat, well, the argument in the present case is effectively inviting us to treat TT, which is commercially wholly dependent on a monopoly supplier, kayak, as being in a vulnerable position, so as the argument runs, to impose, or to enable the court to intervene if kayak takes advantage of that vulnerability to impose conditions on TT which are oppressive in the language of equity, or moral or unconscionable, or morally or socially unacceptable. And if you look at it in that kind of way, one might be asking, is this really an attempt to extend an existing equitable doctrine into the field of commercial relationship?
Well, Lord, it was a matter I was going to try and tackle a little bit later. I've got a feeling that parts of what your lordship has put here is somewhat above my pay grade, but I've certainly got some submissions that I want to make about that. The submission I want to make about it, and let me insert it here and try not to repeat it in due course, is this: if one is not careful in doing that, what we're going to end up with is doctrines which derive from protected relationships imported into freely entered contracts. Now, the difficulty that I foresee with that is that I've already walked your lordships through how this was from 2008 through until 2012, an exercise of a series of negotiations where PIAC could offer such terms as it wants. TT was free to accept them if it wished to. PIAC could terminate the first contract for no reason at all if it wished, and offer a new contract on whatever terms it wished. If you start with that proposition, the importation of the equitable doctrines, if that's what we're going to be looking at, essentially tries to say, therefore, that whereas the common law accepts that two unequal parties can enter into a contract which may or may not be beneficial or advantageous for one or the other, they may be beneficial to start with and become unbeneficial later on. The balance of advantage and bargaining power between the parties may change during the course of the contract. But what one is effectively doing is to say, when the disaster happens, when the dispute arises, we are in fact going to treat one of those contractual parties as being, in effect, in a protected relationship, because they're now in a contract where they are significantly weaker. And the difficulty with that is, we would say, I use the word offensive, it is offensive to common law norms of contract, because what it is in fact doing is allowing parties freely to enter into a contract on such terms as they wish. But once they are in it, a party that is or later becomes the economically dominant one then assumes the role of the person in a protected relationship who has to take care. And that is, we would say, an extraordinary and extreme extension for this or any other court to adopt. Now, we know from the starting sentence of paragraph 59 that Lord Stein used the language of duress, which one would say with some certainty would have known was a common law concept, not an equitable one.
Yes, of course.
Of course. So he knew that he was in the common law, not in equity. He saw it as an extension of the categories of duress. But whether he saw it then as an extension in the way that Lord Reed has just seen it, that it may therefore be taken by him to be an extension of the common law by the importation of some equitable qualities is not entirely clear. But the point that I wanted to make, and Lord, unless there's anything you'd like me for the moment to say on the protected relationship point, which I'll come back to if needs be later on. What the point? The only
point that might be worth adding is that if this is really an attempt, if this is really drawing on equitable thinking at any rate, and trying to establish an analogous concept which could be applied in a commercial context, that might also explain why the mental element is relevant. I mean, normally in contract, you wouldn't be concerned with whether somebody was acting in good faith or not. And in duress, it would be immaterial, because duress is concerned with the impact of the conduct on the claimant rather than what the mental state of the other party may have been. But if you are talking about unconscionability and so forth, then an essential element is the knowingness of the party taking advantage of the vulnerability of a person with whom he's in a relationship, and so, you know, bona fides would be an answer to that.
Lord, we would respectfully agree, and of course, as you know, the form of, I'm going to call it the form of bona fides that we say is relevant is the one that was adopted by Lord Justice David Richards, because that feeds back into what your Lordship has just said about the knowledge of the stronger party.
Yeah, I should say I'm just putting this forward as an idea to just try to understand what the thinking is behind Lord Justice Staines' remarks.
Well, I'm going to have a go at that now, which is always a dangerous thing to do. But the reason I want to do that is because Mr. Shepherd has put his case on the basis that the rationale or the doctrine, and I'll come back to the difference between the two a bit later, is that the critical question we're engaged in is identifying whether something is morally and socially unacceptable. And I've been trying to see where that has come from, because on the face of it, a contractual situation wouldn't normally give rise to that. So, as your Lordship says, bona fides, motive, all completely irrelevant. So in a falling market, someone who's agreed to buy some goods may very well exploit the fact that the goods don't quite comply with their description in circumstances where they would not take that point in a rising market. The fact that they then have a court case about the description of the goods, objectively considered, of course, got nothing to do with the real dispute. The real dispute is the motive of the paying party to get out of paying, because the market's gone down. So the whole concept of this importation into the common law is very difficult if one starts with the proposition that these are contracts freely negotiated between parties in their own commercial interests. So I have had a go at seeing what Lord Justice Steyn may have meant when we get to the second part of that first quotation. And we submit that what he was saying is that once you accept that a case involving lawful act in pursuit of a bona fide claim, that the court's on the slippery slope of being asked to inquire whether the conduct is morally or socially unacceptable. We say the tenor of the judgment of Lord Justice Steyn is that this route, i.e. what I've called the slippery slope, is a misstep, a mistake, which the court should not engage in. He saw it as an extension. He firmly decided against it. And he firmly decided against it in a case involving a lawful act and a bona fide belief in a demand. And Mr. Shepherd's had to do his very best to see how he could distinguish his case from that, and with respect, he can't. Lord Justice Steyn strongly set out policy reasons against what he called at the very start of the paragraph, as I've already said, an extension to the categories of duress. Now, I accept that he went on to say that he would refrain from saying never saying never, as I think we've all wrongly quoted it in our cases, but it's the same point. But that, we respectfully submit, is not the Court of Appeal holding that the test for lawful act duress is whether conduct is morally or socially unacceptable. He was rather using that expression as a reason why the claim in that case was rejected and why the law should not be extended, because that is the route you would have to go down were you to engage in that extension. So with respect to Mr. Shepherd, and I don't mean this in the least bit rudely, to say that this is authority for the fact that the critical question is in a lawful act duress case, whether there's been moral or socially unacceptable conduct, is taken out of context. So I can see that if you lift the expression, the critical inquiry is not whether the conduct's lawful, but whether it's morally and socially unacceptable. If you lift it out of the context of the paragraph, it can sound as if it was laying down the test for lawful act duress, but we say that's a misreading. And I would venture to submit, given the other parts, I'm sorry, Lord Barris.
Sorry, I didn't mean to interrupt you, but just in case you're moving off CTN cash and carry, I don't know whether you are, I'd just like to ask you this question. Would it have made a significant difference in your view, and would therefore the facts have fallen within lawful act duress had Gallagher been acting in bad faith, in the sense that they knew that the risk in the goods had not passed, and that therefore they knew that they were not entitled to the payment price? Would that then be an example, or would you be willing to accept that that would be an example of lawful act duress?
Lord, I've got the answer to that in two parts. It is a critical distinction between whether the party who we're going to call the defendant for this purpose believes that it has a legitimate claim or defence, or whether it knows that it jolly well doesn't. Now, the reason that's critical, and we've developed it in section C of our written case, is that we think that is effectively extortion, because you're making a demand which you know you have no right to make. So the situation is that it is a critical distinction in answer to Lord Burroughs' question. Now, we have put forward the submission that in those circumstances where there is a demand made in the knowledge and belief that you have no right to make it, that brings you into what we've called blackmail territory, because in blackmail, having decided that reporting someone to the police is perfectly lawful, you then make a demand for money not to do so, and you're making a demand which is an unjustifiable demand. Here, if you made a demand that something was given up, jolly well knowing that you have no right to make that demand because you've already concluded that you have no defence, then that we would accept should give rise or can give rise to a remedy. Now, we would prefer that remedy to be recognised as unlawful act duress for the reasons we've given in section C of our written case. But we wouldn't, for the reasons I've started saying that I'm more interested in section B than section C, I don't want to get hung up on the success of our submissions being dependent on pigeonholing one form of economic duress or another.
But I think it follows, if I might just follow up from that, I think it follows from what you've just said, that if it were the case that your clients, that PIAC had known that they had no entitlement to the commission, the full range of commissions anyway, you would be conceding that the other side would have a remedy. You might want to call it unlawful act duress. Somebody else might call it lawful act duress. But the important point is you would then be conceding, that is, if the bad faith issue were held against you. Is that correct?
We stand by what the Court of Appeal has said, that that's our principal case. That is to say that here there was no lawful act duress because we had the view that we had, Hayek had the view it had, and it held that view in good faith, or was not held to have been in bad faith. But whether a different inquiry by Mr. Justice Warren, as it were, addressing the test that your lordship's putting to me, would have led him to come to the same conclusion, might be a different question. I don't know.
I'm actually not. I'm not trying to make this complex.
I'm sorry.
I think you're accepting that there is a good faith element to the inquiry that we must ourselves embark on. Your notion of where good faith comes in is much narrower, perhaps, than other people's conceptions. But you are, I think, submitting to us that it's part of the question whether they really believe that they had a genuine claim or dispute or didn't.
I'm going to come back to what we mean by belief and genuine in a moment, and I want to unpick that, if I may, a little bit later. But the point really is this, that if one accepts the bifurcation of universe tankships, that is to say that if something is unlawful, then that will, generally speaking, lead to the first stage in economic duress being satisfied. If it's a threat to do something unlawful, and then items 2 and 3 are covered, that's likely to lead to a finding of economic duress. On the other hand, if the act complained of, the threat complained of, is lawful, then the focus turns to the nature of the demand. So we accept that, because that, I think, is written into that bifurcation, that the nature of the demand then becomes what the court must look at and what the parties must look at. So is it a demand which is a lawful demand, would be the question. Is one acting lawfully? Are you putting forward a demand which is a legitimate demand? Would be another question of way of answering. So yes, we accept that on the face of it, the courts are drawing a distinction between demands that you're entitled to make and demands that you shouldn't make. And the blackmail analogy seems to us to be right. That if you fall into the situation where you are making a demand you have no business to make, then you run the risk that you're going to be vulnerable to a claim for economic duress, leaving aside for one moment whether it's unlawful or lawful. I'm almost agnostic about that, although we would prefer it. We now see it, having done the work for your lordship's court, as an example, albeit a unique one, of unlawful action.
Yeah. Thank you. Can I just ask you one further question while it's in my mind? And that is, you use the phrase compromise of a bona fide dispute. I think you said, or something along those lines. And I just wonder whether we've got any material that might help us in relation to compromises and that notion of bona fide in that context.
Lord, I'm certainly going to walk the court through the evidence of the dispute in this case, which I think is actually of some importance. Obviously, when one gets this to this level of appeal, getting deeply into the facts can be unattractive. But I think it's worth just going back to Mr. Justice.
I actually meant the general law on compromises.
The general law on compromises. I don't think there's anything from any of the parties on the law of compromises here. The only point I was making, that if, as in effect the Court of Appeal has found, based on what Mr. Justice Warren found as a matter of fact, if what these parties were doing were settling a dispute which had arisen, based on different views they were taking about the nature of that dispute, then it would be a significant move for the English common law to place compromises of such disputes at risk based on the sort of test that Mr. Shepherd's proposing. But I don't think, if your lordship's asking whether there's any material in the 7,500 pages of authorities, I can't recall anything specifically going to that, but we'll certainly have a look if lordship would want. Thank you, Lord Lloyd-Jones. I think you wanted to.
Thank you, Mr. Jones. You draw an analogy with blackmail. Is it an analogy, or are the limits of the remedy of avoiding a contract for duress actually set by the scope of the criminal offence of blackmail?
Lord, actually, it's the latter. I realised when I'd said it that I was slightly departing from what we'd written. Our primary case is that if one, and I'll go in due course fairly quickly through some of the origins of this in the books, but our view is that blackmail is the start of it. And all that's happened since then is various judges, notably Lord Justice Steyn, has said, well, I'll never say never, that it might be something else. And the line we took in the Court of Appeal was that if after 50 years we're still saying never say never, then that's really, it tells its own story. So Lord, forgive my looseness of language. I think I would adhere to the proposition that it's not just analogous, it is. That's it, effectively.
Yeah.
And that's because the criminal offence of blackmail introduces an element of illegality.
Yes, yes. And of course that just as a footnote, I don't think your lordships would need me to go over it. But that's one of the reasons that we, with respect to Lord Leggatt, don't think he's on the right track in Airline and Kent in picking up and then refining the old Larceny Act objective test. If we're in blackmail territory, then we should be in blackmail territory. And we've made that submission in Section V that we should be in the 68 Act territory, not in the Larceny Act territory for that very reason.
Thank you.
So, Lord, Lord Barry's asked me if I was just about to leave CTN, and I had only one small thing to say about it. And I don't think I quite finished it. I would venture to submit, and it's a cheeky thing to say, but I would venture to submit that Lord Justice Steyn would not look down now, or would not like to look down now and see that this phrase, that the critical question, has been taken as authority, that lawful act duress existed as a doctrine, when considering it, that's the test. That I genuinely submit, I don't think is what he intended. When he wrote the passage that is at page 719 of the report and set out at paragraph 59 of the Court of Appeal Judgment. So, Lord, I wanted to tackle that at this stage because it is the cornerstone of Mr. Shepherd's argument that there should be, as was accepted by Mr. Thankey yesterday, a jury question left to the judge based on a multifactorial approach of a range of factors. That's essentially what the case is. In other words, somebody has to sit there on their own and be judge and jury in their own court and make a decision whether such and such conduct taken in the round is in fact morally and socially unacceptable. And the origin for that assertion seems to us to spring from Lord Justice Steyn. And if we're right, matter for your lordships, of course, to say we are not, but if we're right, that is placing far too much weight on the shoulders of that paragraph than it will bear. In fact, we'd go further than that and say that what Lord Justice Steyn meant was precisely the opposite of what Mr. Shepherd now would like it to mean.
So, in that regard, it's perhaps worth mentioning that it's an extempore judgment.
Indeed, I just remember that now. It's not a point I'd thought of as relevant, but your lordship is quite right. It is, and I I think that assists us to say that this was not the Court of Appeal's formulation of the test for lawful act duress. Quite the reverse. Quite the reverse. It was to say we don't want to go down this route because that's what we will end up having to do. So, Lord, I'm going to come back to my note, if I may, and say that it seems to us that your lordships are being offered 4 principal options to choose from. But it may be more than 4 because there's one with some subcategories. The first is that there's no lawful act duress at all. That's our section C. It's the intervener's case that you'll hear this afternoon. The second is that there is lawful act duress, but as expounded by the Court of Appeal, and you know that our primary concern is to defend that. The third is that there is lawful act duress, but with some objective good faith criteria. Therefore, not as expounded by the Court of Appeal. And I'm going to explain in a few moments why that is not as straightforward as it might sound and could give rise to some subcategories, which would be unfortunate and unduly complex. And then the fourth is lawful act duress is expounded by TT. Now, the first is our written case. I say no more for the moment. The second is the Court of Appeal. And I, other than for one point I'm going to come back to about Lord Justice Richards, we sound 4 square behind what is said in that judgment. The third can be broadly labelled as the main dish of the Court of Appeal judgment, but with a side order of objectivity applied to the issue of good faith. And then we get to the TT version, and this is where Mr. Shepherd spent a long time yesterday trying to explain the doctrine and how it should be developed by reference to the rationale of the doctrine. So that's how he put it. He spent a long time on the rationale. So first of all, one has to see where that rationale comes from, and I've already had a go at that in relation to Lord Justice Steyn of Times Travel and CTN. But in a sense, the search for the rationale doesn't help, because you may start with a high-level rationale, but you then have to work out a doctrine that is going to exist in court and be operated by judges and parties alike. And the question here is not whether there is some high-level suggestion that in certain circumstances, illegitimate pressure may give rise to the avoidance of the contract induced by it. We know from unlawful act duress that that exists. We know from lawful act duress, taking the blackmail argument, whether it's lawful or unlawful, for the moment leaving that issue to one side, that exists. The question is, what does the doctrine say about what is illegitimate pressure? That's the point that's at the heart of this appeal. So resorting to an appeal to the rationale doesn't help you, because it begs the question it seeks to answer. The answer here is, what is this court and other courts going to say is illegitimate? You can't turn around and say, well, the rationale seeks an answer to what's illegitimate. Therefore, whatever the judge thinks is illegitimate must be the doctrine. That actually simply won't do. Now, TT's case extends to the following. We have to be clear precisely how radical this is, and why we say this is not Hayek seeking to roll back decades of development, but TT seeking to extend what's been there. And that is, the defendant threatens or carries out actions which are entirely lawful. Defendant makes a demand that is in furtherance of its business and it believes it is entitled to make. And even where the defendant is objectively entitled to make it, Mr. Shepherd still says that even if bona fides is an objective test, bona fides is only one of the factors to be taken into account. So, as I understand Mr. Shepherd's submission, he's not saying that he would rest on objective bona fides. Not at all. And the reason, of course, he can't do that is because if he rests on objective bona fides, he still loses on the facts of this case. So he has to say that even if we're wrong, even if Lord Justice David Richards was wrong about his approach to belief and objective bona fides. Even that doesn't answer the position necessarily in favour of the defendant, because it's only one factor in a multi-factor approach. So the individual trial judge is then tasked with saying whether acceptable boundaries of moral and social conduct have been crossed. Pausing here for a moment, this in a legal system which reaches right round the world and is adopted by people from different countries, different continents, different cultures, different ethnicities, and different business practices, a judge sitting alone is going to be the sole arbiter of a social and moral boundary. So I dealt therefore with Mr. Shepherd's search for the rationale. It doesn't assist him. It begs the question it seeks to answer, and it's the wrong question before this court. So in order to interrogate the four principal options that I put before the court, your lordships may find it helpful to concentrate on the following two main chapter headings. So I'm going to go to good faith first, and then I'm going to go to the development of the law of duress, and in particular economic duress. So, and I'll tackle them in that order: good faith, bad faith. Now, TT say that PIAC should not be the arbiter of the legitimacy of its own conduct. But that, with respect, misunderstands the role that good faith has to play. Lord Justice David Richards, at his paragraphs 105 to 6, made it clear that in this context, good faith simply requires the person making the demand genuinely to believe that it's entitled to what it is demanding. We, with respect, submit that Lord Justice David Richards properly understood the bifurcation between unlawful means, which concentrates on the threat, and lawful means, where the focus turns to the demand. I shall come back to this bifurcation in the review of the authorities, but it's quite clear from Universe Tankships and accepted by judges that followed that that was the critical distinction. And just pausing there by way of a footnote, Mr. Shepherd was suggesting yesterday that he accepted that there may be focus on the demand, but it's still only one of the factors. But it seems to me the bifurcation is stronger than that, because you're now necessarily looking at a case in which the defendant has done nothing wrong and threatened to do nothing wrong, because you're starting with the proposition that it's lawful act. So the focus on the demand then becomes critical, not just a factor. There is nothing unlawful about the demand that was made by PIAC. There is nothing unlawful about saying to an existing or a proposed contracting party that you have a dispute which you wish to settle on specific terms. And there is equally nothing unlawful about being extremely inflexible about what those terms are. Good faith is not a general concept that applies to the legitimacy of the pressure or the conduct being threatened or carried out by the defendant, which is I think, Mr. Shepherd's line. The question is also not concerned with whether the defendant believes that the lawful means by which he seeks to enforce that demand are morally, socially, or commercially acceptable. That's not about that either. The defendant's moral compass is irrelevant. This is also not about dishonesty and the tests by which conduct should be judged to be honest or dishonest, which is the parliamentary intervener's point, and their references to Ivy and Genting. It's about what D believed, which must necessarily be judged subjectively. So the alarm is raised by Mr. Shepherd. This hands over to the defendant the ability to be the judge in his own case, but this is a wildly overstated concern. It is said, if it's said that there's no justification for the defendant's professed belief in its demand in a trial, no doubt that will form a central plank of the claim, and judges will be astute to reject assertions of belief when they can see no grounds for it. the judges, we respectfully submit, have all the levers at their disposal to ensure that a defendant is not improperly left to be the arbiter of its own beliefs. But if the defendant does believe in the propriety of its demand, now in CTN that would be a demand for money. In our case, it would be a demand to settle a dispute. So the belief there is in a defence rather than in a claim, but the point remains the same. If the defendant does believe it, and that is accepted by the court to be genuine, then if you'll forgive me for putting a forensic question, in circumstances where the defendant is acting entirely lawfully, because that's the concept that we're dealing with, and the factor that converts lawful action into avoidable contract as the demand, why is there anything wrong in taking the line taken by the Court of Appeal? Put another way, what is wrong, what is offensive to the common law, the contracting party or would-be contracting party making a demand it believes to be genuine as a condition of offering a contract it is not bound to offer in the first place? Because that's the position here. The position here, that the first contract was lawfully terminated and a second contract was voluntarily proffered. So let me break this down further, because this goes back to the key points that I started with. What is offensive to the common law if PIAC terminated the contract and offered no new contract? And I just invite your lordships to contemplate that proposition for the moment. The answer must plainly be that there is nothing offensive about it. Now, the court formed the view that TT would have gone out of business once its contract was terminated. So that is what must be assumed for this purpose would have happened. Contract terminated, 30 days later, TT out of business. Now, it's quite possible that any liquidator would have lacked the means to sue for the earlier commission. Pure speculation, but perfectly possible. If the liquidator could bring proceedings, then we must assume that a claim would have followed with some value, but that TT's business would have been destroyed, because that's what the judge held. But PIAC offered TT a new contract, and thus offered TT the chance of survival, which it was not contractually entitled to. But the judge held that if they wanted to survive, they didn't have a choice. But he didn't hold they didn't have any choice at all. If one was a supplier of dairy products to a major supermarket chain, and entirely for this purpose captive, and the supermarket said, we're terminating your contract unless you reduce your price below cost price, well, that was perfectly entitled to do so. And that supplier may not have a choice, but it's perfectly lawful conduct and nothing flows from it. So they could have chosen to lose the new contract, go out of business, and rely on suing for their money via an insolvency procedure. Now, if one just assumes that for the moment, this case wouldn't exist. There might have been a claim by a liquidator for the money, which has happened anyway, because that was the trial in front of Mr. Justice Warren. But if I can stand back from it for a moment, I'm not trying to build up a moral case here. That's not my purpose. I'm just saying PIAC, in fact, objectively, offered TT the chance of survival, and they took it. And it appears to have worked for them because they're still in existence. But out of those facts, PIAC is being held up to vilification on the basis, Mr. Shepherd says, that it acted unlawfully, notwithstanding that they may demand a demand which they believe they're entitled to make, and where the court did not condemn PIAC as acting in bad faith. Accordingly, if one stands back from the smoke swirling around this case, which is understandable because the issues are complex, the simple test as decided by the Court of Appeal about what we're calling subjective belief, or subjective good faith, just to give it a label for the moment, is not offensive at all. In fact, it's entirely correct, with respect, because it recognises the fundamental starting point that however robust PIAC were, they acted lawfully. Everything they did, taken separately, was entirely lawful, and there was a genuine dispute to settle in respect of which it believed in good faith it had an effect. Now, I've got to pick up a point made by APPG yesterday, and that is, they say this Court of Appeal's treatment of good faith as being subjective ignores recent jurisprudence on good faith. And this is the sort of Ivy and Genting point, and it's paragraphs 37 to 41 of their written case. I'm not going to take you to it. Lord Burrows.
Sorry, just before you move on to that.
Yep.
As I understand it, your submission is that this case crucially turns on PIAC genuinely believing that it had that it was genuinely entitled to dispute, I should say, the rights alleged in relation to the Commission.
Well, it's the claimant's claim, not the defendant's
yes.
defence that we're looking at. So I'm only saying if this claim was to stand any chance of success, bearing in mind the point we've made about the nature of the demand, which we discussed about half an hour ago, then the claimant would have to put submissions before the court at trial and ask the court to make a trial finding that PIAC had no genuine belief in its defence, and as a result of that, its assertion of any defence, and thus the consequential desire to settle the claim fell the wrong side of the blackmail line because they had legitimate interests. So,
yes.
So that's what they'd have to prove, and they haven't.
But wasn't it clear that in relation to at least part of the Commission, PIAC couldn't possibly have believed that it had a right to dispute that small part of the Commission? Isn't that right?
Lord, no, it's not right with respect. And I did say earlier on, there was one item of Lord Justice David Richards' judgment that I was going to quibble with, and it goes to that very point. So I will be coming to that, and not before long, but I will be coming to that because I think it's an important point of the facts that your lordships will need to interrogate.
Yes. And then just one final question in relation to this, if I may. Might it be said against you that what you're proposing favours those who make mistakes as to their legal entitlements?
Well, making a mistake as to their legal entitlement is a perfectly legitimate and justifiable thing to do, and it happens every day of the week. People take legal advice, the legal advice is wrong. People debate with their lawyers what's going to happen in cases. They don't always turn out in court in the way that it was anticipated. So the idea that it might lead to a situation in which you can have a mistaken approach to something doesn't mean that you should then be held to have an avoided contract in circumstances where nothing you have done is unlawful. So, Lord, I come back to the proposition that this isn't the question of whether it's a mistaken belief or a genuine belief or all the various formulations of belief we may come up with. While that is the focus of the nature of the demand, one must never forget, we respectfully submit, in working out what the answer to that question is, that this is all in the context that what is being done is entirely lawful. So the contract, and that's in a sense what one is trying to balance. We are trying to, we would submit, balance up what constraints there might be on perfectly lawful behaviour in a contractual context where the parties have entered into contracts freely, and as I've always said, TT was entirely vulnerable to being taken out of business at 30 days' notice, with no right to a new contract at all. So that's the context in which we're trying to evaluate what happens. So APPG, they've said paragraphs 37 to 41. I'm not going to to draw your attention to them now, other than to give you the references. That we've ignored, or the Court of Appeal ignores current law. With respect, that they're wrong, because the cases they've referred to concern a positive duty to act in good faith. And for example, I'm not going to get involved in whether implied duties for good faith and so-called relational contracts should exist, do exist, and what they're affected. But we all know that there are discussions in the law about duties and obligations. Let us assume for the moment that such can be judged objectively and by reference, say, APPG to what they call honesty plus. So I think Mr. Rowe yesterday called it good faith properly understood. But whether an alleged juressor's demand is made in good faith is in a different context, and that's the point I've been trying to make. I think it was the answer that I gave Lord Burrows a few moments ago. The context is different because what we're dealing with is lawful conduct. It's not about the manner in which they've done something, which is the case when performing contractual obligations. It's their motive and belief when doing something, which in Pyack's case, it was insisting that TT gave up its claim for commission. The first deals with conduct. That's the Ivy-Genting approach to dishonest conduct, for example. Got nothing to say about that because the context is wholly different and it is irrelevant. The second deals with whether a contracting party, normally considered to be free to act in its best interest so long as it's acting lawfully, can be held to account for making a demand. That's the principal issue. Rod, there's a couple of minutes to go, I think, on this, and then I'll suggest a break if that's convenient to your lordship, because I've just got half a paragraph to complete. If what we were talking about is the extraction of a completely unlawful windfall, that is to say, unlawful to the knowledge of the demander, the juressor, because he knows he's not got a claim or he knows he doesn't have a defence. That's one thing. And if lawful act duress exists, then we stand behind what the Court of Appeal say. If we're right about blackmail, then if that would qualify as blackmail, then that would give a remedy as well. But if they have a belief in the demand, then their otherwise perfectly lawful conduct does not become unlawful because, unbeknown to them, a judge has later held that the claimant was right and the defendant wrong. In any event, I'll take you in a moment that this isn't a case where the claimant was wholly right and the defendant wholly wrong in any event. So that I think is going to bring me back to some of the points that I just discussed with Lord Burrows. So, Lord, if that's a convenient moment for your lordships, if you want a short break, if you don't want a short break, then I'm happy to carry on. So I'm entirely in your hands.
Yes, Mr. Jones.
To be headed that the concerns about good faith and the latest law on good faith are red herrings in the present case, because it's not what we submit that the courts should be engaged in. And I just wanted to look at some authorities to see if there's anything to help us about that. And I'm just going to look at one and leave the other one for a footnote. The one I want to look at is CTN, and the page number is 1430 for the first quote and 1433 for the second. So this is 1430, Lord Justice Staines' judgment, and it's the very foot of the page, a very simple sentence. Although the property and the goods hadn't passed the plaintiffs, the deputy judge found that the defendants thought in good faith that the defendants were at that time at the plaintiff's risk. That is not challenged on this appeal. A simple reading of that would be that, that there's no objective overlay on the face of it. If one goes down to 1433, we see then a reference from Sir Donald Nichols and that is at letter G, where the defendant company insisted on payment, did so in good faith, it believed the risks in the goods had passed to the plaintiff, so it considered it was entitled to pay for them. The defendant company took a tough line, it used its commercial muscle, but the feature underlying and dictating this attitude was a genuine belief on its part that it was owed the sum in question. On the face of it, those two passages would support the proposition for which we contend. But what I now want to do is to pick up that which was addressed by Lord Justice David Richards in the Court of Appeal judgment. I'm sorry, I can't quite remember the page number, but we were paragraph 59 earlier on, and I'm now going to just remind you of what was said in that judgment between paragraphs 59 and 62. I'll give you a page number in a moment.
It's 221.
It's
221, thank you. Now, you could see this in CTN itself, but it seems to me it's just as easy to pick it up from the Court of Appeal judgment. So 59 we've already looked at. There's a reference to Lord Justice Steyn, and at paragraph 60, he quotes the Vice-Chancellor, and it's the second quoted passage that is of interest. So that's at the foot of the page. I should say that the remarks were au pair of the Vice-Chancellor because they weren't picked up by the other Lord Justice, but for this purpose that doesn't matter. So what he says is this: further, there is no evidence that the defendant's belief was unreasonable. Indeed, we were told by the defendant's counsel that he'd advised his client that on the risk point the defendant stood a good chance of success. I don't see how payment demanded and made in those circumstances can be said to be vitiated by duress. Now, Lord Justice David Richards then considers the consequences of that in his paragraphs 61 and 62. 61, it was critical for the decision that the defendant acted in good faith. Lord Justice Steyn added that in a purely commercial context it would be relatively rare for lawful accuracy to be established, etc., etc. Sir Donald Nichols, Vice-Chancellor, agreed, but also laid some emphasis on the absence of evidence that the defendant's belief was unreasonable. 62, in my view, CTN can be taken to establish that where A uses lawful pressure to induce B to concede a demand to which A does not bona fide believe itself to be entitled, B's agreement is voidable on grounds of economic duress. It cannot be taken to establish that if A genuinely but unreasonably believes the demand to be well-founded, the same result follows. While it may be that the Vice-Chancellor would have favoured that outcome, it runs counter to the judgment of Lord Justice Steyn. So, having set myself the task of drawing your attention to what there may be in the books about this seemed to me an appropriate place to start, because there's no doubt that Lord Justice David Richards picked it up. There's no doubt that he addressed it and in his mind resolved it, and we commend that resolution to this court. Now, the point I want to pick up, which is of importance here, is that the Vice-Chancellor's comments went to the reasonableness of the belief. He specifically mentioned the evidence to that case, in that case to that effect, that the defendant had received advice and so on. So while the Vice-Chancellor's opening comments referred to reasonableness, that reference was to the belief itself, i.e. asking were there grounds for the defendant to believe. And they do not suggest that a genuine belief would be undermined just because, for example, the issue underlying the demand was later the subject of a trial which the defendant lost. That's a different question. I only make this point because Lord Justice David Richards has, with respect, fallen into one error when considering the evidence. And to make this good, I need to spend a few moments on the facts. To do this, let me just do a very short review of the claims. I wish to make a general point to start with. Mr. Shepherd presses the point that PIAC forced TT to abandon accrued claims in the same way as the owners did in Progress Bulk or Mr. Ting did in Borelli. But with respect, that is not a fair conclusion. The only permissible reading of the judge's findings of fact is that PIAC compromised a genuine dispute. It has to be recalled that Mr. Ting knew that he was vulnerable to claims when he demanded their resolution, and Progress Bulk knew perfectly well that they had no defence. Now, in the claim we're talking about, there were essentially three claims. There was a claim for 9% commission on all sales from 2010. That's October 2010, and that's the date that I've given your lordships already. There was a claim for overriding commission from 2008. And there was a third claim that the basic commission should be calculated including the YQ element. Obviously, if the first of those defences was correct, or the first claim failed, then the YQ element would be irrelevant post-2010. That's why that date is of significance. Because the defences to those claims were as follows. The first defence to the 9% commission from 2010 was that it wasn't due because it had been changed to something called net sale remuneration. A different scheme was in place. The defence to the overriding commission was that it wasn't due at all. And the defence to the basic commission, the YQ point, was that it wasn't due on the YQ element. So it wasn't to be counted as part of the fare for the calculation of the commission. So one defence to that pre-October 10, not to be counted. Two defences after that, after 2010, A, not to be counted, and B, it didn't matter because if the first defence was correct, then the YQ element didn't arise. Now, the judge held that PIAC was wrong on the first claim because there was no adequate notice given in October 2010 to trigger the change. The lordships have already looked with me at paragraph 260(1) as to what the judge said about PIAC's belief in that defence. The judge then held that the ORC claim, the second one, overriding commission, failed in its totality. His decision on that is at paragraph 223 of his judgment. I don't need your lordships to turn it up, but in due course, I would invite you just to read what he said. But there is a worthy footnote here. Mr. Shepherd pressed on you yesterday the proposition that PIAC repeatedly told TT that it would pay the commission. And in support of that, he referred you to paragraph 224, little 2, 224, little 2. Now, I do appreciate he was going quickly at this stage, so I may have misunderstood it. But all 224, little 2 says is that PIAC on some occasions between 2008 and 2012 told TT that it would pay overriding commission. Well, that's different from all commission, and as we know, in due course, the TT claim for overriding commission failed. Now, on the 9%, so the first claim, the 9% commission, which is the largest of the three, he heard evidence and argument, he made his findings in 11 paragraphs, and just for your note, between paragraphs 209 to 219 of the judgment. Now, when Mr. Justice Warren then came to deal with this in his judgment, I've already referred you to paragraph 260(1). Again, I'm sorry I don't have a page number, but it will be given to me in a moment. I'm now going to invite you to look at paragraph 260(5).
Two 297.
Yeah, thank you. Now, it's a bit of a, with respect, a little bit of a muddle what's in this paragraph, because it deals with both the claimant's claims on the defendant's claims all in one go. But it says the claimant's claims were all genuine and arguable. He then says the YQ claim in respect to the period to the 16th of October was very strong indeed in the light of the decisions of the Australian court and Master Leslie. I need to pause there for a moment and say that the decision of Master Leslie post-dated September 2012. So on the face of it, this cannot be addressed to Hayek's belief. What it's looking at is the strength of the underlying claim. Had the summary judgment application proceeded, and I believe that was a possible summary application by TT. Had that proceeded, it would, in my view, have been bound to succeed, is what he says about that claim. The claim to 9% basic commission, including commission on the YQ element for the period after 2010, was less clear. For the reasons which I've given, I consider that it would have been a good claim. The ORC claim is one which, on the evidence before me, I have rejected. So that is not dealing with questions of belief, as in paragraph 260(1), and it is not addressing the reasonableness of that belief, because the learned judge addressed that when he considered good faith, bad faith, and famously said it had neither been proved by the claimant, and the defendant hadn't proved that they were in good faith. Now, Lord Justice Richards, as you know, said that when we see in that paragraph, it's paragraph 262(2), it says the claimants have not established that there was bad faith. And so that should have been the end of the inquiry. And with the greatest respect, we agree with Lord Justice David Richards. It's the claimant's claim. And if, as they now say, bad faith was a factor, they failed to vindicate it. I've already made the point about the Master Leslie judgment and the inevitable consequence that that brings about. I'm also going to say, if I may, that when Hayek turned up to that hearing, it wasn't a claim, it wasn't a proceeding between them and TT, it was between them and somebody else, because the TT claims at that stage had been compromised. They were represented by leading counsel, not me, and one might be entitled to say, on the face of it, there was some consideration given to the fact that there was a defence. The fact that some of the defences, one of the defences was absolutely spot on, which the ORC claim was thrown out. The 9% claim was arguable, but on the evidence failed. And the YQ claim was stronger and would have been subject to summary judgment if something else. Just simply addresses the question of the underlying objective merits of those claims. It doesn't deal with what the Vice-Chancellor was dealing with, which is whether the defendant, for this purpose, had a belief that there was a defence. And it doesn't deal with the reasonableness of that belief. What paragraph 260 is dealing with, and exclusively dealing with, is not the reasonableness of belief in the defence, but the underlying merits of the defence. And I'll remind you about what Vice-Chancellor Nichols said in CTN by reference to the fact that the party in that case had received legal advice. They'd been told they had decent defence. So it's perfectly possible, so far as the Vice-Chancellor was concerned in that case, for you to have a belief, and that belief might be assisted by the fact that you've received advice. He wasn't remotely concerned with whether that belief was correct if you judged it by the subsequent underlying merits. Now, in saying that there is one passage in the Court of Appeal judgment with which we disagree, that takes me back to paragraph 112 in the Court of Appeal judgment, 112. It's the very, very last page of that judgment. My Lords, I'm sorry, it's entirely my fault. I should have these numbers to hand, and I apologise to all of you that I do not. Your Lordships may have found it by now. It's the last page.
234.
234, thank you very much. You're very kind. So what we see here, page 100, paragraph 112, can I just read it? The position concerning lack of reasonable grounds for advancing or rejecting the claim is complicated on the facts of this case because it's only the claims of pre-October 10 YQ Commission, which according to the judge's findings was rejected without reasonable grounds. Now, pausing there for a moment, if what Lord Justice Richards meant by that is that it was rejected without a belief in the defence, and there were no reasonable grounds for that belief, that, I'm afraid to say, does not emerge from the judgment. That would not be its proper meaning from the judgment. The only thing that can address is whether the underlying objective merits of the claim fell above or below the summary judgment standard, because that's all Mr. Justice Warren said. And that is uniquely not an answer to the question whether the defendant had a belief and whether it had reasonable grounds for that belief, which was the point that was being addressed by Vice-Chancellor Nichols, and which was the obiter approach that Lord Justice Richards was addressing in the two earlier paragraphs, 60 and 61, that I took you to. So if Lord Justice Richards was indicating that, and it's not entirely clear whether he was or wasn't, but if he was, we would respectfully submit that's wrong, and it doesn't emerge from the facts, and there's no factual warrant for that from Mr. Justice Warren's judgment. Now, what he then went on to say is this: it represented only about 4.5% of the claims on which Times Travel succeeded, and only 3.75% of their total claims. So that's because the YQ element pre-October 10 was worth about £56,000. Would that be enough to avoid the entire release of the claims of Times Travel if a lack of reasonable grounds were a basis for finding of illegitimacy? So here, again, with respect, Lord Justice David Richards appears to have cross-wired two questions. He's cross-wired the question of whether there were reasonable grounds to defend the claim, objectively analysed subsequently by his decision, or whether at the time we're uniquely concerned with, September 2012, the defendant believed it had a defence and had held that belief on reasonable grounds. And therefore, what one can't, this is coming back to Lord Burroughs' point, and I hope is a satisfactory answer to it, as it certainly intended to be. And you'll see that I was alive to the point because I prepared this analysis before. I haven't done this on the hoof in answer to your question, Lord Burroughs. We would say this is a complete answer to that point. In other words, what one must, and Lord Burroughs, of course.
You may regard this as somewhat hypothetical in the light of what you've just said. Could you help me on this question, though? Say the position had been that they had no genuine belief in respect of the claim representing only about 4.5% of the claims, the YQ Commission. What would the position then have been on your analysis?
Well, Lord, your Lordship is right to say, I'm going to say it's hypothetical, because I think the answer to that would have to be that if one was addressing that at the trial, you would have to then address everything in the round. You'd have to look at the effect of that, if that was the offence. So if you were isolating at the trial one piece of offence, for want of a better word, that is to say, the advancement of a defence in respect of £56,000, which was not believed to be correct in circumstances where we know the claim was a seven-figure claim, I'm just trying to think of the legal principle that might deal with this situation. That's what's in my mind.
If we were against you in your interpretation of what Lord Justice Richards has said, it seems to me that we're then faced with applying your proposition, a genuine claim or genuine belief that you are entitled to defend a claim for commission for the vast bulk of what is here being talked about, bar a very small amount.
Well, I think the answer.
And I just wondered if I might say, is there some answer to that that would allow one to say, well, we might unwind part of the bargain to allow a repayment for some of it, or is this all just too complex to deal with? It's an all or nothing, I suppose, is what I'm trying to say.
I would deal with that on the basis it's A, all or nothing, B, it's something that would have to be resolved at trial with findings specifically directed to that issue, because of course if one imagines your lordship's giving the sort of judgments we very much hope you'll give in this case, and then imagine what happens to a times travel type case in a couple of years' time when they've digested it. What the parties would be doing would be working out answers to those questions with factual consequences and factual findings. But I don't have to go to any of those. I'm not dodging the question, because I think it's a rather difficult one, and I don't understand why Lord Justice David Richards didn't want to tackle it, because he didn't have to. But it seems to me it is all or nothing because it's de minimis in the context of the case.
I wonder, apart from showing that there was conduct which might amount to duress, you would also have to show that it had a causal effect on the transaction, and unless the £56,000 was critical, it might very well have had no causal significance.
Well, Lord, that's the point I meant about resolving it at trial, because you then not have an isolated question about issue 1 of lawful act economic duress. You'd have to look at issues 2 and 3 as well, in order to decide what the effect of that was. But my Lord, I've endeavoured to answer Lord Barrow's question, as it were, hypothetically, because I do understand entirely why you would ask it, respectfully. But can I say in the facts of this case, it simply doesn't arise, because at the end of the day, the judge did consider whether we were acting in good faith or bad faith, and he said that the allegation that we were in bad faith had not been vindicated. So that, on the face of it, must be a complete answer. So while we stand foursquare behind Lord Justice David Richards' analysis, and why we say he's right for all the reasons that I've endeavoured to suggest, in other words, that if your starting point is that someone is acting in all other respects lawfully, then this is a proportionate response of the law. If you fall foul of the personal belief test in your ability to make a legitimate claim, then you make yourself vulnerable to a duress claim. That's in a sense the essence of it. But if you don't fall foul of that, then the law won't interfere. That is a proportionate, measured response to what is otherwise entirely lawful activity. That's the point I've been trying to make. But we still win. Forgive me for coming back to the point that I know your lordships are going to be necessarily focused to some extent on the wider points and the wider principles. But if my purpose here is to defend Pyack's position under the Court of Appeal judgment, we win in any event, because there's no doubt that the first trial court rejected the proposition. We were not in good faith, but we were acting in bad faith. And that, as Lord Justice Richards said, is the end of the inquiry. So Lord Justice Richards has, in a sense, made a rod for his own back in paragraph 112, because on one view, on the facts of the case, he didn't have to go there. And my reference to Mr. Justice Warren's findings of good faith, bad faith, don't of course turn on whether Mr. Lord Justice David Richards has, as it were, wrongly translated Mr. Justice Warren's findings into his judgment. But I can just rely on the fact that the suggestion that Pyack had acted in bad faith had not been vindicated, and that must be sufficient for me. It cannot now be permitted that TT is entitled to say, well, if objective good faith is the test, the judge wasn't expressly directing his mind to whether his paragraph 262 went 265 went to good faith or bad, objective good faith or subjective good faith, therefore we win. The answer is they must then fail. They must bear the burden of that. So I have no hesitation in saying that by the time we have looked at Mr. Justice Warren's judgment, whether or not it's correctly transposed into Lord Justice David Richards's judgment in the Court of Appeal makes no difference, because we are entitled to hold on to the Court of Appeal judgment based on the underlying facts in the trial. And there's only one circumstance in which we win, and that is if Mr. Shepherd can persuade you that we need to go down the exotic moral responsibility line and extend economic duress in the way that Lord Justice Stane resisted. So let me just pick up, unless there's anything any of your lordships wanted to ask me arising from that. I know we've stuck on it for a bit because it's obviously an important point and arises from analysis of the facts. But what I would just want to say in very final submission about this, on the facts we say TT failed to establish that PIAC did not hold a genuine belief in its defence. It also failed that to establish that if it held such a belief, that belief was not reasonable or wasn't held on reasonable ground. And you can't undermine that simply by saying some years later, in 2017, I think the trial was in 2017, 5 years later, the judge made the findings he made. And I've already made the point that the reference to Master Leslie must logically indicate that Mr. Justice Warren was not addressing the Vice-Chancellor Nicholls' question of belief on reasonable grounds, because that's a wider question. And of course, again, we come back to submission I've already made. If that was a relevant question at trial, and it perhaps ought to have been, whether it wasn't pursued as it might have been, is an entirely different question. Who gives evidence about it, what evidence is believed, what evidence is disbelieved, and what submissions are made, are all matters for trial. But as doing the best we can from this judgment, we win on this point. It doesn't matter which way. Simply doesn't matter. So coming back, may I loop back then, please, to the categories, the four categories I gave you of objective, subcategories rather, of objective good faith. And I did say that depending on what you think about this, you may end up with subcategories if good faith has to be objective. So you may have to formulate it on whether the reasonableness of the belief in the demand is the correct test. I'm going to call that the Vice-Chancellor Nicholls test, if I may, because at least we have something in the authorities to lead us to that, and it's quite clear what he was talking about. You then might talk about reasonableness as to the underlying merits test, which is, I think, Lord Burroughs' question to me arising from paragraph 112 of Lord Justice David Richards's judgment. I've dealt with that. Well, the third possible might be an objective analysis of the good faith of the overall conduct. Now, you've already got my submission, I hope, about the third of those, which is that it's the wrong inquiry. The inquiry here is not to do with the overall conduct. The inquiry is about the demand. So we just, pulling all those strings together, we say that we don't have to go further than this part of our submissions, because the Court of Appeal test is clear, it's easy to apply. I would respectfully submit that neither the Court of Appeal, and unquestionably I don't have to submit, nor your lordships, are constrained as to what you hold in this case by any prior authority. And therefore, we are happy to rest on the fact that the Court of Appeal's decision is clear, easy to apply. Judges have the tools at their disposal to disbelieve a defendant who is trying it on, asserting its belief in the demand in a way that the court will not accept as genuine. That's the way around it. And that conclusion properly reflects what I've said earlier on, so I'm not going to repeat it, but in short, it reflects the uniqueness of lawful act duress, where the starting point is that everything done by the defendant is lawful, and one is testing the alleged culpability by reference to the demand. Obviously, the demand in the context of all the lawful activity, but it's lawful activity. One still keeps coming back to that one fundamental proposition. Your Lordships did ask me, Lord Burrows, I think, asked me whether there was anything in the submissions about compromise. We've certainly referred to paragraph 32 of our written case, but I think that probably doesn't go as far as Lord Burrows was asking me about, but there is some reference to it. So I'm now going to move on. I think at the moment I've got essentially 1 hour left. So I'm going to move at some speed, if I may, just to get through some other points. But the core of what we want to say, the core of why we should succeed in this appeal, and the core of why Lord Justice David Richards was right, is something that I think already dealt with, and therefore, if I lose some of these tail-end submissions in the wash of time, it's not going to be the end of the world for us. So. Can I just invite your Lordships to have a think about the evolution of duress, and I'm going to give you some quotations, because obviously this is a case in which all the parties turn up referring to the same cases, because actually there aren't that many. So that's very clear. But when one really looks at them, we think some fairly broad principles emerge. The evolution of the doctrine of duress was threats of violence, threats to property, and nothing else. And that was all resolutely unlawful activity.
It could also be, for example, deprivation of liberty without necessarily violence, but some interference with the person.
Yes, yeah. So again, I may have been too blunt in my definition there, but it amounts to the same thing.
Yeah.
Then we move on to the possibility of economic duress. There's absolutely no question in this appeal that the concept of economic duress exists and has been applied time and time again, but it's all centred on threats of unlawful conduct. Where this appeal has struggled to find authority and principle to support it is in the field of lawful conduct. And we would say that that it's really not a coincidence. And we'd say that because unlawful conduct goes to the heart of why the doctrine exists. And that's it. The doctrine isn't there because it undermines the consensus between the parties. I think it was being suggested by Mr. Shepherd yesterday, the focus is on the wrong party. The focus should be on the claimant, on TT, and its will and ability to make a proper decision and a proper contract. But the modern view is not that there was no true agreement. The modern view is that the law simply refuses to uphold that agreement because, as a matter of policy, the stronger party shouldn't prosper from the unlawful conduct. So why in those circumstances has the possibility of lawful act duress come into being? What is it that has caused that to happen?
Sorry to interrupt you, but you seem to be suggesting that rather than the rationale being that the freedom of choice of the claimant has been interfered with, rather that it's to do with a sort of idea of ex turpi causa affecting the other party to the transaction who's abused his power. Is there authority supporting that?
All I was saying was, perhaps I went too far. All I was saying was that the justification for it is not that the parties, there was no true consent between the parties. It's that reference to the fact that you might be under huge pressure, but you still agree. And that's the only point that I was seeking to make in that. So why out of that background have we ended up with a concept of lawful act duress? How has that come into being? And when one looks at it, and I'll just give your Lordship some case names and some page numbers, but I'm not going to take your time to go to them. Barton and Armstrong, page 1976. Sorry, page 949, forgive me, 949. The quote is, the pressure must be one of a kind which the law does not regard as legitimate. That's the point I've made earlier about, if you like, what's the rationale. But now we've got to find out what that question means. Universe tank ships, very, very important. Page 2315. What's important about that is blackmail is the only example given where a threat of lawful action was assumed to give rise to duress. Lord Scarman does not contemplate any other example. Now, that doesn't mean to say that it's ruled out. I'm not saying that was expressed as being definitive, but it's interesting that in its origin, when the bifurcation was clear, that's what we were talking about, it then becomes interesting point that at that stage, no one was suggesting anything that went beyond blackmail. So if we can pick this up from some items in our written case, if you'd be kind enough to allow me to do that, I wouldn't normally take your lordship's court to a written case because you can read it, but all I want to do is to highlight some relevant sections, please. So we find this at starting at page 105. I'd like to start, if I may, page 108. Well, this is going to be something of a whistle-stop tour, but I don't apologise for that because almost every one of these cases you've had brought to your attention already. So, the 108, our paragraph 10, Mr. Justice Carr, in the Occidental Worldwide case, English law only knows duress to the person and duress to goods. That was his position then. Paragraph 11, North Ocean Shipping, Mr. Justice McCatter, as he then was, compulsion may take the form of economic duress if the necessary facts are proved. The threat to break a contract may amount to such economic duress. So this begins to show us how this is building up. Power on, which is Lord Scarman and the Privy Council in that case, that again was a threat not to transfer shares in breach of contract. So this was a unlawful act case. We've put a footnote there to say that the line Lord Scarman took in that case was all about coercion, but the test is lower than that. So that's not what that which is there for. Paragraph 13, universal tank ships. The reference you'll need for that is at page 2315. I'm not suggesting we go there straight away. And this was in relation to tortious conduct over the page. The threat was therefore unlawful and amounted to economic duress, or unlawful economic duress as we would call it now. Paragraph 14, Dimskel Shipping. Again, it was an unlawful duress case, unlawful act duress. So paragraph 15, we've reviewed those cases, and then we've tried to find out what happens when lawful act duress is considered. And here there is a quote in relation to universal tank ships. And I am going to invite you to read this quote with me. It'll be in the case, but it's accurately quoted here. So the paragraph 2, the second part of the quote, in determining what is legitimate, two matters may have to be considered. The first is the nature of the pressure. In many cases, this will be decisive, though not in every case. And thus the second question may have to be considered, namely the nature of the demand which the pressure is applied to support. The origin of the doctrine of duress in threats to life or limb or to property suggests strongly that the law regards the threat of unlawful action as illegitimate, whatever the demand. Duress can, of course, exist even if the threat is one of lawful action, and whether it does so depends upon the nature of the demand. And I've called that the bifurcation case because when we know what kind of action it is we're looking at, we cease to look at the threat and we look at the demand in order to decide whether the doctrine is met and the pressure is illegitimate. Blackmail is often a demand supported by a threat to do what is lawful, e.g. to report criminal conduct to police. In many cases, therefore, what one has to justify is not the threat, but the demand. So paragraph 16 supports the bifurcation that I have been talking about. Paragraph 17, I only want to refer to the case you've already looked at, which is Thorne and Motor Trade Association versus Lord Atkins judgment, which you've already seen. When he was talking about the offence of blackmail, this is right at the foot of that paragraph. If the cause is reasonably capable of being associated with the promotion of lawful business interest, then there is no offence of blackmail. So we have made the point, and I'm going to footnote it here for you, that we should win this case on any footing, because this was the promotion of lawful business interests. Quite apart from the fact that I've already made submissions to you along the lines that on the facts we should win in relation to what was bona fides and what was believed, we've got lawful business interests as well. Over the page, paragraph 18, this is the two passages from Lord Hoffman in the Attorney General case, which your Lordships have already been referred to. And it's quite clear from that he's looking at the nature of the pressure and secondly, the nature of the demand. And then the second passage, the threat of any form of unlawful action will be regarded as illegitimate. On the other hand, the fact that the threat is lawful does not necessarily make the pressure legitimate. So that's not a statement of the positive, but it does nothing to alter that bifurcation approach that we've already alerted to. So paragraph 19, we say it is only where the threat is accompanied by an illegitimate demand and thus amounts to blackmail that relief will be granted. Because if one stops to think about it, it's only in those circumstances where the test can be satisfied, unless you go for Mr. Shepherd's exotic test, the fourth category of moral and social responsibility test. So the last sentence of 19, we say, this is the proper conclusion from these authorities. There is no scope for the court to equate lawful conduct with unlawful conduct on the grounds that it is beyond the pale or by reference to some other vague standard. Now, we've then got a heading called the legitimacy of the demand, and I've dealt with the majority of this already, but I just want to alert you to one or two passages. Paragraph 20, we pose the question, how is the court to judge the legitimacy of the demand? Well, we say that's easy. We fall back on blackmail, because that's in fact the origin of it, Universe Tax Ships, Lord Scarborough. And your Lordships are obviously aware of the difference between the Larceny Act and the Theft Act, so that's all set out here, and I'm not going to spend time on it. But it's quite clear that subjectivity is the key to blackmail since 1968. I'm then going to go over the page to our paragraph 24 and decide everything before then, and simply say this, that in TT's written case, Error 194, they do say blackmail is an entirely apposite analysis. It would introduce a marked inconsistency in the law if the civil law did not provide relief for what is a serious criminal offence. Now, as I understood Mr. Shepherd yesterday, he was, I think, saying at one point that this was a case of blackmail. I'm going to come back to that in a minute, because it wasn't. That's not a submission open to TT. But also he was saying that there may be cases of blackmail which don't qualify for economic duress. I suspect he was doing that on the basis that his approach is more open texture, and therefore, if he doesn't want rules, he shouldn't have rules. But it's very difficult to see in the circumstances why that which constituted the offence of blackmail would not, if it had led to a contract, lead to that contract being set aside. It would be perhaps an odd decision by this court or any court to say that a contract induced by a criminal offence was something that the court had no power to deal with. And in a sense, that's why we've wrestled with whether the blackmail consequence, because it would be a very unattractive consequence for anyone to suggest that blackmail wouldn't give rise to the right of the court to intervene. And the only question then becomes which file you'll put it in. Do you put this in unlawful act duress, or you put it in lawful act duress? And the more we thought about it, as I've said earlier, the more we thought about it, it looked to us as if it sat happily in unlawful act duress. And the reason we've promoted that is for this reason. If we were suggesting to your lordships that lawful act duress should be put out of its misery, as I've colloquially said, then there has to be an answer to what we do about blackmail, if that induces a contract. And the answer is it sits perfectly happily in unlawful act duress. But if your lordships are unhappy about that, well, then we wouldn't be submitting. Therefore, it can't sit in lawful act duress, but we would be submitting that it's the only example. So that's how we put that. Now, let me deal with a point I made a few moments ago, because I said I would come back to it in a minute, and that time is now. It was said by Mr. Shepherd yesterday that Kayak did commit the actus reus of blackmail. In our submission, he was quite wrong about that. Thorne is authority for the proposition that if the defendant is acting in furtherance of its business interests, it isn't blackmail because it's legitimate. And he suggested that Kayak wasn't acting in further of its business interests, but this stems from the misunderstanding and misstatement of the fact. It might be, and might have been proved on different evidence, that Kayak would be making an unwarranted demand in the blackmail sense if, like in Progress, Bulk and Borelli and Ting, there wasn't a genuine dispute about whether it owed TT the money. But I've already been through that. There was a genuine dispute. There was a genuine dispute in relation to all three. One of them, the dispute actually succeeded in the defendant's favour. Now, for practical purposes, coming back to Lord Burroughs' all or nothing point, it would be very difficult in circumstances where a claims assessed by Lord Justice David Richards in the Court of Appeal to be worth between £250,000 and £300,000, being pressed by TT on Kayak, which Kayak subsequently won, and that case was dismissed, could possibly give rise to a suggestion that the suggestion that that claim be settled in clause 6 of the agreement was an unwarranted demand. It would be an absurd starting point. And the facts of our case are very clear, and I don't need to go back over that. But it would, in those circumstances, it is not a submission that's open to our learned friend, and I'm afraid we reject it wholly. There are no shades of grey in our rejection of the suggestion that Kayak committed an act of blackmail or the actus reus of blackmail. It is utterly and totally contrary to the facts, and utterly and totally not open to TT to allege it. Now, if we then move on to CT cash and carry. So I've come back from the blackmail point for the moment, and just looking at what we then get. In fact, it's better if I stick with objective blackmail for the moment and just take you over the page to 114 of the case, which I hope you've still got on your screen, because we've given you a fuller passage there of Lord Atkin's speech in Thorne. And it says, it appears to me that if a man may lawfully in the furtherance of business interest do acts which will seriously injure another in his business, he may also lawfully, if he's still acting in furtherance of his business interest, offer that other to accept a sum of money as an alternative to doing the injurious acts. Comes back to my Lord Reed's point yesterday about if we'd offered to enter a new contract if they paid us £1 million. That is precisely what Lord Atkin was talking about. paragraph 28, may I commend this to you? That is Lord Justice Beatson's article. I never know in these circumstances whether I should refer to him as he was when he wrote it or as he subsequently become. So I intend no disrespect if I stumbled over that. The use and abuse of unjust enrichment, very interesting. In many cases of blackmail, the blackmailer has no economic interest in the outcome apart from getting what he demanded. Where he does, the question will be whether the demand is unwarranted. And a demand will not be unwarranted where the person making it believes that he has reasonable grounds for making it, and the use of the menaces is a proper means of reinforcing the demand. So that's the Lord Atkin point, and we commend it to your lordships. So I've already dealt with the relevance of the defendant's belief, so I needn't go back over that. And just very finally on this, whilst we got that case open, please, paragraph 62, which is your page 127 on the screen, 127. I have made the point in oral submissions that whatever the outcome to the good faith debate, we should win. And we have put there the reasons why that is so, to which I think might be added what I'm going to call the all or nothing de minimis point, arising from Lord Justice David Richardson's judgment at paragraph 112, which is his we would respectfully say stumble in relation to the possible stumble in relation to the YQ claim, and the reference is there. You see, it's obviously a tiny part of the overall dispute. And the rest of that, that's just to remind you where it is. I've covered all the ground in paragraph 62, I think, already in the course of oral submission. So coming back then to how lawful act duress has emerged, it really emerges then from the bifurcation in universal tank ships and has taken further forward in CTN cash and carry. And I'm not going to take you to that, but for your note, it's 1428. Now, there's also some interesting reasoning in Lord Debenture's written case, paragraphs 16 to 20. Again, that's not for me to take you to it, and I don't want to take my time on their case, but we do endorse their reasoning. Now, there is a reference in CTN cash and carry that you'll recall, I'm sure, to Professor Burke's when he was talking about what to do about outrageous but technically lawful conduct. And Lord, I just want to spend a moment or two, if I may, trying to unpack that, because I'm not sure where one goes with those sorts of descriptions. My understanding has always been that conduct is either lawful or it's unlawful. It can't be technically lawful. So I'm not sure how that really helps. And again, we've made strong submissions that we shouldn't be going down the moral outrage route proposed by Mr. Shepherd. And an expression of something as outrageous doesn't really help in formulating a doctrine that is going to be applied in a practical sense. So we then end up, if you like, looking at progress bulk, and from progress bulk, we might look then to Borelli and Tink. But essentially, our case, and again, I'm coming back to the distinction between my sections B and C, we have suggested that these cases can be properly considered by your Lordship's Court as falling factually into unlawful act duress. Now, our case does not depend upon that before your Lordship. That's in section C. That is addressing the question, how comfortable will this court be in saying lawful act duress does not exist, were it to be confronted by cases, viz. One in the Privy Council, which had given a remedy on facts which you need to be satisfied might still give rise to a remedy. So our concern here is that you do not think that we're advancing in Section C a proposition that needed ever to have ended up with different decisions on those two cases. And the distinction of the judges involved in all the cases we're talking about, it's a point made by Mr. Rowe yesterday, is frankly was almost outstanding. Yes, progress bulk carriers, Justice Cook, extremely experienced commercial law judge. But we have put forward the proposition that those cases can sit in unlawful act duress if you want them to, but we're not going to the wall over it because we don't have to win on that proposition in order to sustain our claim. Second, our defence to this appeal. Secondly, what we are saying in relation to belief, and what we're saying in relation to upholding the Court of Appeal's approach to belief and good faith, would not in either of those cases have ended up with a different result. So it's important for your lordships to know that we are not either in our Section B or our Section C inviting you to make a decision which would have the effect of overruling those cases. So, and we don't need to. Lord Burrows, of course.
Just to be absolutely clear what's being said, I think your paragraphs here are 35 to 48. And as I understand it, your submission is, even if we assume that Progress Bulk Carriers and Borelli are cases of lawful act duress, they fall on the other side from this case because on those facts there was no genuine belief.
Absolutely.
In relation to the legal entitlement. So that if we were to accept that there is a concept of lawful act duress, those two would be cases that you would accept fall on the other side of the line from this case.
Yeah, I would be forced to accept. I'm grudging. I'm not being grudging at all. I will accept that if we are standing firmly behind the Lord Justice David Richards' Court of Appeal judgment, that's the consequence. So the consequence would then be that you're addressing the question of belief, you're addressing the question of bona fides as it was decided by the Court of Appeal, and in Progress Bulk, absolutely without question, they knew perfectly well they were in repudiated for breach of contract, no question about that, and they just used their muscle to get out of it. And in Borelli and Ting, I can just take you through a few points about Borelli and Ting, if you'll forgive me, just to make good this point. And it's actually, so I've picked up the wrong piece of paper. Yeah. So the facts of Borelli and Ting are quite interesting. He refused to cooperate with liquidators in investigating the affairs of the company, Akai Holdings, of which he was its former chairman and chief executive. Liquidators proposed a scheme of arrangement transferring shares in order to raise funds, which required shareholder approval. Mr. Ting did all he could to prevent such approval being given. He deliberately made the liquidator's job difficult. There's reference to forgery and fraud in the presentation of his evidence in the Privy Council decision. It reached the point where the scheme of arrangement was likely to fall through. On the day before the deadline for the scheme being approved, he applied pressure to the liquidators to enter a settlement agreement to waive claims against him and to cease investigating his conduct. Now, subsequently, they investigated the conduct and discovered that he'd misappropriated funds in large quantities. I'll just give you the reference. Paragraphs 27 and 28 of the Privy Council judgment. Privy Council found that he had refused to assist the liquidators in the investigation, and because the only reason he opposed the scheme or of arrangement was to prevent the liquidators from obtaining the funds they needed to continue with their investigation, he was acting in bad faith. In other words, the quote is, his opposition was not made in good faith, but for an improper motive. And the improper motive was that he knew that the liquidators did not, that he was guilty of substantial misappropriation. That's what he knew. So he was getting from that settlement agreement what he knew he was not entitled to get because he was liable. And he must have known that. So paragraph 32 is a key passage, and I'll just read it out to you. It says this: in view of the board, Ting's failure to provide any assistance to the liquidators, his opposition to the scheme, and his resort to forgery and false evidence to further that opposition, amounted to unconscionable conduct. Coming back to Lord Reed's earlier point, that I think was you made a reference to Attorney General, but we also pick up that reference in Ting as well. Against the background of his failure to cooperate with the liquidators, as it was his duty to do under the winding up rules of both Hong Kong and Bermuda, had he not opposed the scheme for purely personal and selfish reasons in the process using forgery and false evidence, then there would have been no need for the settlement agreement. In other words, by agreeing to withdraw the opposition to the scheme, he did no more than he should have done from the outset, and he acted in bad faith. So this is, if Borelli and Ting is a lawful act duress case, if it is, taking as read for the moment the suggestions we put in our written case that it is not, it's because the relevant threat was his threat to veto the scheme. Now, that was his right as a shareholder, but it's clearly distinguishable from our case because of the finding of bad faith. And the finding of bad faith is because he knew that he had misappropriated funds. He was acquiring a settlement to which he knew he had no right.
The alternative analysis, I think, is to treat the, rather than consider the threat in isolation, to see it instead in context as part of a course of unlawful conduct.
Indeed, and it's quite clear, for example, that the reference, I don't disagree with that, Lord, because the reference to using forgery and false evidence in and of itself is just part of that conduct, and one can see from that paragraph that, in a sense, the kitchen sink was thrown at him for the purposes of arriving at a correct answer. But I didn't want to rely simply on the kitchen sink point, because I wanted to be able to identify why it was, being precise and a bit pedantic about it, possibly, why it was that the demand he made for the settlement was a demand he knew he wasn't entitled to. And that's, in a sense, the correct analogy with why we would say that you would not have to overrule it. In any way, were you to follow the Court of Appeal.
I think a moment ago I may have put it too broadly. Even if you focused on the threat, the threat was to veto the scheme in breach of his legal duty to cooperate with the liquidators, wasn't it?
Yes, well, that's what we've developed as an unlawful conduct case, because he had obligations to cooperate and he didn't.
Yes, and if you look at it more broadly and take the view, if you took the view that it wasn't unlawful in principle for him to decline to approve the scheme, if his declining to approve it is part of a course of criminal, well, in this case, was it criminal? Well, certainly unlawful conduct.
Certainly unlawful.
Then you would say there's unlawful conduct for purposes of duress.
Yes. So we think, your lordships, should be up. Let me put what is really the purpose of us looking at progress bulk and Ting in this context. I think it's no more than this. It is to give your lordships, if we've managed to achieve it, the comfort of knowing that you can dispense with unlawful act duress if you think that's the right thing to do, or you can keep it and support the Court of Appeal's approach to it if you think that's the right thing to do. And neither of those needs to cause you to implicitly or explicitly say anything untoward or formally to overrule the results in those two cases. That, I think, is the comfort that we were trying to offer this court, but to a very large extent, it's to give you the widest possible canvas and the fewest constraints on your ability to make the decision. What I think, it's not for me to run your lordship's clock, and I apologise if that's impertinent, but I may have come to lunchtime.
We're all finding this so interesting that time is going more quickly than we appreciate. We'll adjourn now then until 2 o'clock.
I'm very grateful, Lord. Thank you very much.